In this video, we're going to be looking at the rule against perpetuities, and this is going to form part of a two-part series on this particular topic. So let's explain it. It is in the public interest that property, both real and personal, should be able to be alienated freely. There is a rule that property may not remain in trust perpetually or for too long a period, and this is known as the rule against perpetuities, or perhaps more accurately, the rule against remoteness of vesting. So, one of the most common causes over the years of invalidity of interests under a trust has been the failure to comply with the rule against perpetuities. Since medieval times, English law has been subjected to the tensions between two conflicting influences. Owners of land and of other types of property have generally wished to tie up their property indefinitely, usually for the benefit of their family or for some institutional cause, while the courts and the legislature have always felt that it is in the interest of the nation as a whole that property should not be made inalienable and that money should be allowed to circulate freely and be spent. And so the result has been a compromise. This is a rule that derives from public policy. In other words, it is a public policy and good economic sense that property, both real and personal, be alienated, so that is sold or given to someone else freely. Property should not remain in trust perpetually or for too long a period, otherwise all property would end up in a trust. And this is the purpose of the rule against perpetuities. So there was an early reference to the rule against perpetuities came from this particular case. And it was stated that a perpetuity, as it is a legal word or term of art, is the limiting an estate either of inheritance or for years, in such manner as would render it unalienable longer than for a life or lives in being at the same time, and some short or reasonable time after. I have joined estates of inheritance and for years together, because the law does equally abhor what is called a perpetuity in the one as in the other, the reason of which abhorrence is the mischief that would arise to the public from estates remaining forever or for a long time unalienable or untransferable from the hand to another, being a damp to industry and prejudice to trade, to which may be added the inconvenience and distress that would be brought on families whose estates are so fettered. So, it is contrary to public economic policy that property should be held in trust, unable to be bought or sold for too long a period. You cannot render it unalienable longer than for a life or lives in being, and some short or reasonable time after. So that is the old rule against perpetuities. In other words, a trust can last for the duration of one person's life plus a short or reasonable time after, which has been historically 21 years. Okay, so a trust under the old rule of perpetuities could only last for the length of one person's life plus 21 years. 21 years being the time of which the children need to reach their majority. Okay, and until the late 1960s, the majority was 21 and not 18 as it is today. And at which point they would become entitled to hold the property. Absolutely. And let me just put this another way, because I know some people will struggle with this concept of perpetuities and the rule it sort of is encapsulating. So in other words, if a person dies after they have a newborn child, the 21 years gives the child long enough to reach the majority plus a possible 9 months. Because if, let's say, the life tenant is a man and the property is held on trust for him during his lifetime, and then his children upon the youngest of them reaching 21, it is possible his wife is pregnant at the time of death, in which case it will take 21 years plus 9 months for the child to reach majority. Although there are no cases on the extra 9 months, it is commonly accepted that this would be the case. So that is the traditional rule of perpetuity. all private trusts must have a provision for their ending within a certain period. If there is no such provision, the trust may be void. In that case, the trust property will return to the settlor on a resulting trust. So all private trusts must have a provision for their ending within a certain period. This is usually done by vesting any property left over absolutely into the children, grandchildren, etc. of the settlor. If there is no such provision, the trust may be void. And traditionally, it was automatically void, but the law has slightly changed. If a trust is void for perpetuity, the property will return to the settlor on a resulting trust. So in other words, it will go back to the original owner. Okay. So before April 2010, the trust property had to vest. In other words, the legal and beneficial title had to be held by the same person or persons within a life in being plus 21 years or within 80 years. A life in being was usually the life of the first beneficiary, but could be someone else's life, such as a member of the royal family, which was actually seen in the case of Re Hawley Town, where a perpetuity period in this particular case was 21 years after the death of the youngest descendant of George VI, living in 1948. Before April 2010, then, the trust property had to vest within a life in being plus 21 years. So you could set a fixed perpetuity period that in 80 years the property vests in the beneficiary, goes to charity or whatever. Okay. Now, this rule allowed the settlor to leave property to his or her children and then to his or her grandchildren within the property vesting with the property vesting in the grandchildren when they reach the age of 21. Any attempt to control the disposition of property beyond that point, i.e. beyond the perpetuity period, was held to be void and would invalidate the trust. The life in being test allowed a life interest to be held by a person and the remainder to pass to their children on reaching 21. There was a possible gestation period allowed so that property could pass to a child envenst sa mère at the time of the life tenant's death. So that is the possible 9 months extra. Okay, so let's have a look at something called the wait and see rule now. And under the old rule, and that is under the common law before 1964, the mere possibility that property might not have been vested before the end of the permitted period was enough to invalidate the trust ab initio, that is from the beginning. And this was the basis of the judgment in Air Jamaica and Charlton in 1999, a Privy Council case from Jamaica in which the old rule against perpetuities was applied. Okay, so although this is a relatively recent case, Jamaica still relied on the old common law of equity. So that is the law before 1964. They have no statutory provisions on perpetuity. And the rule in Jamaica, the law in Jamaica was the same as the law in England and Wales before 1964. So in other words, the law in Jamaica applied the common law in that there was just a possibility the trust would continue for longer than the life in being plus 21 years, then it would be automatically void. Okay, so this was a case of a pension fund which provided a pension for Air Jamaica employees on retirement and for their widow and designated beneficiaries after death. So employees, when they joined the company, joined the pension scheme, and money was automatically taken out of their pay packages and put into the pension pot. The employer Air Jamaica made contributions to the pension pot too, and when the employee retired, the accumulated pension pot was used to provide the benefit for the employee on their retirement until the end of their life, and the benefits of the pensions goes to the widow until the end of the widow's life too. Okay, and it was held that each employee's pension fund was a separate trust established at the time that the employee joined the scheme. The power to provide benefits to widows offended the rule against perpetuities, as it was possible for a person to marry after the constitution of the trust, a person who had not been alive at the date of constitution. So it was held that each employee's pension fund was a separate trust. In other words, if you had 5,000 employees, there were 5,000 separate trusts. Each of these trusts had to comply with the rule against perpetuities. The trouble was that the power to provide benefits for a lifetime to the employer as well as the widow until her death offended against the rule against perpetuities because it was possible for a person to marry after the trust had been formed, a person who was not a life in being at the date the trust was constituted. So, explained in more depth, if the employer and his wife are both alive when the trust is created, they are lives in being, and therefore the trust would be valid because the trust would only last for the remainder of their lives. However, if the employer is 18 when he signs the trust, he will become the life in being. If his future wife is not born yet, then the employer will become the life in being. The wife who he marries later will therefore not be a life in being. As the trust in this case is meant to be valid until the death of the widow, who is a beneficiary, it would only be possible for the trust to be valid if the widow died within 20 years of her husband's death. And remember, the rule against perpetuities would mean the trust would have to end within a life in being plus 21 years. As the employer is the life in being, for the trust to maintain its validity, the wife would, as I just mentioned, have to die within those years. As the trust said, the property is vested in her for the remainder of her life, because otherwise she has outlived her perpetuity period by the mere fact that she stays alive. Yeah. So, for example, a person who joined the scheme at the age of 18 might, at the age of 50, marry a 30-year-old. If the employer died at the age of 60, if the employee died at the age of 60, the widow or widower aged 40 at the time of death would easily survive for more than 21 years after the death of the beneficiary, thus making the duration of the trust more than a life in being plus 21 years. So the life in being the employee, and the 21 years is the maximum time for any children alive at the death of the life beneficiary to reach majority and be entitled to absolute ownership. So it was possible to join the pension scheme when they were 18 and start working for Air Jamaica. So it would be possible to marry someone who was not alive at the date the trust was formed, and that person would then be entitled to widow's pension, and she may live for more than 21 years after the death of the employee. And in those circumstances, the trust would subsist for longer than a life in being plus 21 years. So the trust was said to be for the benefit of the employee, then his wife when he died. If both were alive at the time the trust was created, this would not fall foul of the perpetuity period because they would both be lives in being. However, if the wife was not alive when the trust was created, the employer would be the life in being. This would mean that when he died, the trust would have to come to an end within 21 years of his death. However, because the trust allowed for the pension fund to invest in the widow until her death, it was very possible that the trust could run for longer than 21 years after the employee's death, thus falling foul of the rule against perpetuities, 21 years plus a life in being. Because that was a possibility, that was enough to invalidate every single trust in the pension scheme. And as a result, Lord Millet said that every single pension fund under the scheme was invalid because under the old rule, pre-1964, the mere possibility was sufficient to invalidate a trust. And just before the change in the law, the following case happened. Pilkington and Inland Revenue Commissioners. So in this case, the trustees exercised a power of advancement which allows the future beneficiaries to receive up to half of their expectant share of the trust capital to create a new trust for the 5-year-old daughter of the life beneficiary. So this is about the Pilkington family, who made a fortune out of glass. And in this case, the father was a beneficiary under a trust. He was a life tenant of the trust, and his daughter had remained in the trust. In other words, she would come into the property when her father died and she had reached 21. What the father wanted to do was to set up a new trust for his daughter, okay? And the trustees had a power of advancement, and this allows the trustees to give property to someone who will become entitled in the future. And this is an express power in the trustee. So as long as the life beneficiary is okay with it, the trustees can give some up to half of the trust money to a future beneficiary. In other words, as the trust said the daughter would be entitled to the trust capital when her father died, but the power of advancement meant she could get up to half of the trust capital before her father died. And he was okay with that and said that money could be taken out of the trust fund to settle a new trust for the benefit of his daughter, who was 5 at the time. So the plan was to take money out of the trust capital and use it for the 5-year-old to set up a new trust for the benefit during her lifetime and for the benefit of her children too. Okay, as the new trust was born out of the old trust, the perpetuity period was taken as from the establishment of the old trust. As the daughter was not alive in being at the time of the old trust was created, the new trust was void. Okay, so the resettlement is fine, but there was a problem. The daughter was not born when the first trust was set up, and if you take money out of an existing trust and use it to set up a new trust, the perpetuity period must come from the old trust. In other words, as property was taken out of one trust to set up a new trust, the House of Lords held that the perpetuity period should date from the formation of the original trust and not the new trust. So you cannot create a new trust out of the old trust to get around the perpetuity rules. As the daughter was only 5 years old and not born when the father's trust fund was set up, she was not alive in being, so the trust failed and was void for perpetuity. So the money went back to the original trust. The reason was that there was a possibility, or rather a probability, that the daughter would outlive her father by more than 21 years, in which case the perpetuity period, and in which case the perpetuity period would be exceeded. Okay, and this was sufficient in 1964 to invalidate the trust. So this was another case in which the old pre-statute common law was applied. And there was a specific response to this case, and in 1964, the Parliament passed the Perpetuities and Accumulations Act of 1964, and it was in this case that the wait and see rule was introduced. Okay, excellent. I think that wraps up part 1 of my video on the rule against perpetuities, and I've explained a couple of key cases about the rule against perpetuities and the wait and see rule. And in the next video, I'm going to talk a little bit more about the Perpetuities and Accumulations Act, with a little look at accumulations and the rule against inalienability. And that's about it. So if you have any questions about this video, please leave a comment below and I'll get straight back to you. And don't forget to like this video and subscribe to my channel. Thank you very much for watching.